It's rare that somebody comes and asks me to talk about fashion. Fashion. Look at me, come on. But the reality is that a topic has come up in copyright law relating to fashion that is of interest for the next 2 minutes. That is the following. Can a cheerleading uniform be protectable by copyright? As the court has said, a cheerleading uniform is going to be full of stripes and chevrons and zigzags and color blocks. And it turns out that the first manufacturer here had a particular set of those units of color and design. And the second manufacturer apparently came up with a set that was considered to be substantially similar. The question before the U.S. Supreme Court is going to be whether that kind of design can be protectable by copyright. For a lawyer like me, who is only a little tangentially related to the fashion industry, the question has always been defined by a case from about 35 years ago, where it was whether a belt buckle could be protected by copyright. And the court there made a kind of simple explanation, which was that part of the belt buckle, which is basically holding up your pants, is not protectable by copyright because it's a utilitarian object. But if you have a belt buckle that has a design on a sculptural design, something that, hypothetically speaking, you could remove from the belt buckle and standing alone it would be a piece of art, then even on the belt buckle, it's protectable by copyright. The question here is whether these designs, these color designs and blocks and zigzags and chevrons on a cheerleader's uniform is sufficiently interesting and takes us away from the utilitarian object concern of copyright law, that it will be protectable. The U.S. Supreme Court will hear the case in the fall, and by sometime next spring, we should have an answer as to whether that kind of design is protectable by copyright.